InSight, Byte, welcome back. Public law, what is it good for? InSight Byte 2. So for many years, the federal government of Australia have a strong policy which requires executive officers to detain people who come to Australia without a valid visa. And this is particularly pointed at people who try and arrive by boat, a unique problem for a continent nation. But there was a sentiment that people arriving by boat somehow jumped the queue. So many people apply offshore in their home resident country to come to Australia. And, that process may take years or, certainly months. And then you either get granted a visa or you don't. But to just turn up on the shore, and there was a desire to disincentivize that practice of risky carriage from neighbouring lands to come to Australia. So the Migration Act authorised executive detention and a very strict policy around offshore detention. So you weren't even going to get here. If you did get here, we'd take you somewhere else and process your application there. And the idea was that would deter risky, leaky boats, people smugglers who were capitalising on human misery and suffering in states of unrest, like wars in Sri Lanka and Africa, and etc. So we have the authority of the Migration Act, and this is a federal statute setting out the rules as to who can or cannot enter Australia. And this power gives the executive right to detain asylum seekers whilst their visa is being processed. Now, the scope and ability of that power has come into question a number of times before the High Court. And in Al-Kateb and Goodwin, on 2004, the Migration Act required executive officers to take persons who arrived in Australia into detention. Now, it was a bit of a catch-22 with Mr. Al-Kateb, as he was a stateless person. So he was a Palestinian born in Kuwait, so he didn't actually have a home state. So where under the Act, either he was detained until he got granted a visa, or if he got declined a visa, he had to be removed from Australia back to his home state. Well, what happens if you don't have a home state? Can it be right that the Migration Act authorised the executive branch to detain Mr. Al-Kateb indefinitely, like forever? So, two issues before the High Court, and if so, A, was it indefinite, and B, well, is that constitutionally valid? So, devil's in the detail. The catch-22 arose by virtue of the provisions, section 198. An officer must remove as soon as possible a non-citizen, and the officer must, section 189, must detain a non-citizen, an unlawful non-citizen who's arrived. Section 196 says an unlawful non-citizen detained under 189, which Mr. Al-Kateb was, must be kept in immigration detention until it is either removed under other sections, deported, or granted a visa. So a minority of 3 judges found that, properly interpreted, the Migration Act did not permit the executive for indefinite detention. However, the majority felt under McHugh that there was such authority. So according to Gleeson, Chief Justice, the Act does not say what's to happen through no fault of his own. He cannot be removed at 577. and the possibility that a person can be subjected to indefinite and perhaps permanent administrative detention is not one to be dealt with by implication. And that's that statutory presumption against punitive measures or restrictive measures being allowed to happen by creep or without intentionality. So McHugh points out that under Chu King Lim and the minister, the court decided, do you remember, under section 51, that the Constitution extends to authorising executive government to detain an alien in custody for the purpose of expulsion or deportation. And Chu was around whether that was punitive and therefore and significantly Lim as well talked to the object and operation of the Migration Act is to ensure that non-citizen should be kept in custody until she leaves Australia or is given an entry permit. And they felt in Lim the prima facie fall within the scope of the legislative power with respect to aliens conferred to by section 51. So there was power for the executive to detain. So as long as it's not a punishment, so therefore it's not in the exclusive domain of the courts, it would not infringe Chapter 3 of the Constitution because it's not a punishment. Therefore, it's not the exercise of judicial power. And the Justice McHugh said it's just the same as someone ejecting a prisoner of war or detaining the Australian government, the executive detaining a prisoner of war until you could deport them. So it's nothing to do with punishment. So therefore it's not infringing the court's inherent jurisdiction. So this authorises executive detention, administrative detention, not punitive detention, by virtue of the power to control migration. Okay, next InSight Byte. What about the Australian executive trying to outsource offshore refugee or non-visa holders detention lawfully? And then if following the offshore detention in an overseas or a foreign sovereign state like Nauru, like in Papua New Guinea, then whose custody or detention are they actually in?